court cases and your man nine be Abusuapanin Tupac and lawyers and presented it to High Court and said, here when it comes to the injunction or opposite lawyer and the true celebration of life of that lumber. And I spoke from a layman's perspective, right? Probably maybe I wasn't able to break it down to your satisfaction. I spoke to a lawyer friend yesterday, and then he agreed to speak on the matter to explain the things basically to us. So you are going to enjoy that conversation. The only thing about the conversation is that it's not an audio conversation because he doesn't want his face to be seen. It's not a video conversation. I mean, it's an audio conversation. So you're going to enjoy that. If you're delve into it, don't subscribe and part to subscribe. Man, I like it. Nothing else post notifications. Never forget to share. Hello, good afternoon.
Afternoon.
Patrick, say be able.
Oh, na me adom.
Okay. If I saw a idea and your bonina, assembly na mene menkofo be ntiase and I say yedebema obia owonim dia o law Ghana emra ne ho na nka wa kye mu kakra. Patrick say kwan wo ho.
No, wow.
Okay. If I me send the documents earlier, I don't know what check here concerning
documents.
Okay. And na yenti nyoma bi ase. Yes, it be a plaintiff and will be a defendant. But beginning and plaintiff no defendant no difference near day.
Okay, so plaintiff near Obia or no de assem no Aquadine court.
Okay.
Or no asking or no a report an issue at the Ama court.
Okay.
And a defendant name for who I have both in sema plaintiff maybe Aquadine court. Or more moving woman say or maybe young court and a defendant. And see, basically, in conform one bar sem. Over court say Obi Sema and you see the word allegedly. So for allegedly, I go muti.
Okay.
Say Sendiano our court. To a lay person or the defendant, in for plaintiffs now report your Modiama court.
Okay.
Okay. So because something in law the friend of the court or no so bet me assembly because one no so bet me about the file case as a friend of the court.
Okay. If I show na asemi mede bi ma o document bi na nyoma 9B yes plaintiff na no na ode cause nka ye be ye ne beje se nka betimi a break is anyama down because law bro for no ye nti ase ati ase nka betimi a break ne down ma ye nyina ya ti ase anki ne beje pa.
Okay.
Anapacho miame kin kan ma ona
what's a
Pacho bana mi buza se miame kin kan ma wana ana wa be kan na wa chirim
me kan ne ma chirim what's a mega
Pacho I'm going to say first one 9 first one a declaration that the plaintiff as Abusuapanin of the Akosua Serwaa family of Akosua Serwaa has the sole and exclusive authority to organize, supervise, and approve the burial and funeral rites of the late child Akosua.
Okay, so with this, what basically what they are seeking for is the authority over the funeral. Plaintiff, I hear Abusuapanin because one or your family head. And then under account customary law, you say family head normally on the final say. It's about a year home to say, and I say any other family engagement. Abusuapanin, and what the final say. But then Abusuapanin must also act for the family members. And this is also o take it down and say Abusuapanin so ominaya adenko. So what the Abusuapanin is seeking or the plaintiff is seeking that it should be established or rano and who is the onona or what authority over the funeral. So basically that's what our first claim no and it was also responsibility so obey organize it a year no obe supervise again, obe sign approve all the related funeral rights are the course. But anything else are authority. So that's basically what the first claim is talking about. But what the one say? Okay.
Okay,
So
to make me second one.
You've got the second claim.
Okay, the second one, I'll say a declaration that the burial and funeral rites, a funeral ceremony held on 13 December 2025, constituted the final and valid funeral rites of the deceased under the Akan customary law.
Okay, so basically, idea also and also first funeral rites somewhere back in 13 December. We say in Mano established another court and establishes sa funeral rites no muyema bed lumba no final valid.
The 13 December no.
Yes, final valid, and then customary to they should recognize it as the funeral, meaning the court may agree. For the legal, the disease has already been properly buried according to tradition because the final funeral rites from the customary law. In some say and manage to say legally you see that the man say you can't according to the traditional way you bibia kama other day, and then no further funeral or rites are necessary or valid or should be held. What do you say?
Yes, Honor. Okay. Third one, I'll say a declaration that the defendant's proposed celebration of life events scheduled for 28th and 29th March 2026 is unlawful, unauthorized, and contrary to Akan customary law.
Okay. So I think last week, this was just last week now, defendants and almost funeral life. Now, in some plaintiffs, can say, have funeral rights March 28-29, 2026, plaintiffs need to or did he say unauthorized, any international unlawful, and then it's against one thing I also the account custom because normally a year they buy account mambrana. Me person may take care because at time court nankata every decided but where in some plaintiff or claim for we ain't say over account mamu a year they ain't about quoi and on some occasions maybe even say family maybe a baby a family you need now put a drink family members may say oh you be by your mom at that time is moving.
Oh, okay.
Claiming say the defendants in here, it shouldn't be valid because it is against our account custom. It is unlawful and I find unauthorized. I'm going to say court a ruling as illegal. Any kind of kata celebration of life, no matter funeral right celebration, a caution.
Okay. Okay. Now, celebration of life, any funeral ceremony, difference woman.
It depends. It depends. But also the course it was basically like a funeral writer almost year be on the first date plaintiff, a year that was 13th December 2025.
Okay. And the next one I'll say an order of perpetual injunction restraining the defendants, their agents, assigns or privies from organizing, performing, advertising, felicitating or holding any further funeral, burial or celebration of life in respect of the list.
Breaking it down is basically a permanent ban.
Into perpetual injunction, a permanent ban.
Permanent ban. This is may aspect the court should rule in favor of them to stop the defendant from organizing any funeral memorial.
Or celebration of life.
Yes.
Or in respect of the late Charles Kojofosu, aka Dad Lumba.
Yes, and then holding any celebration of life for the disease, which is Charles Kojofosu, that Lumba. So they should stop it. It's asking the court to tell them to stop it. That should place a permanent ban on it.
Okay. And also I'm buying or say.
And I mention meaning the court granted and under no circumstance should the defendant organize such an event without the plaintiff's permission. Without the plaintiff's permission.
Okay. Mpatwani. Mpatwani. Meeting out also.
Which one was?
5. Now say an order restraining the defendant from using the name, image, likeness, or identity of the late Charles Kojo for commercial, fundraising, or promotional purposes without lawful authority.
And the way they know, plaintiff, court and stop the defendant from using the disease name, image, and then the likeness, which means they don't even want posters and then flyers for the event. They don't want anything that will be out there in social media talking about any fundraising activity tied to the funeral. Also, normally with the posters, any invitation cards, call out for funeral, inviting people to come and help you. At the actual meeting, so Buana, Muni, Enfi, and Honor. That is the uncle. Almost present in a plenty of HMA or person defendants, maybe you see any of flyers, baby, invite you, be actually be ambassador funeral. Already now, planes now, you can both in the almost keep a permanent ban on any celebration of life or funeral or anything. So, of course, that there's no way about the flyers and our posters. But if you are seeking for something, you have to lay all those provisions down. Then they are clear. The Yama course no much may deliberate as well.
Meet me out also with the next one, right? Okay, so the next one is an order of interim and or interlocutory injunction pending the final determination of this suit, restraining the defendant from proceeding with the advertised event scheduled for the March 2026 or any similar event.
With the honeydew.
Or say an order of interim and or interlocutory injunction pending the final determination of this suit.
Interlocutory injunction it's more like an immediate stop or temporary order.
Okay.
A permanent ban.
Okay.
But it be at any year.
Okay.
Also, any moment from now, to the ISR celebration of life in any way. What the plaintiff is saying now is that the court should give out a temporary order to immediately stop that celebration of life at airports. It shouldn't happen. It shouldn't happen while the case is still on trial or while the case is still ongoing. So for now, what you might be attending any celebration of life a process and defendants in the bar concerning these funeral rights and the court should prevent that. They should temporarily stop that until say they are sending in our age.
Okay. Pacho, and the next one, I'll say an order restraining the defendants from soliciting or receiving donations from the public in the name of organizing any funeral or memorial ceremony for the deceased.
In the you know, she no be anko any fundraising there, and you look at the defendants, of course, to pay for any money. I mean, fundraising concerning disease funeral rights. Because somebody is attending that to a court and once a court it shouldn't happen. Any kind of defendant and court decision can so a baby or the year.
Okay. And the 8th one is costs, including legal fees.
So and then the asema babe dan court on to me and so that without claiming for any damages and and the only better defendant in legal fees any other related costs or more care concerning case here with the babe dan court and so basically claiming for damages and seeking for relief on damages and the actual legal fees and then other related costs.
Number two, say, anka, as from my senka, any dear, you can say, defendants, dear, on small plaintiffness on court. That also trying legal.
On only chamber the court, it was any in his favor. He has that right to seek for an equitable relief or remedy or damages cost. Because on no paying or no at the adult court and say we should see him as the only authority, as being fun to say leader. Oh no way to me I am to say concerning the year of honor this year. So this year no one time now but so he has every right to do that. Everything will play about court and these things.
Okay, and a ninth one, I say, any further order or orders that His Honorable Court may deem fit in the circumstances.
And only what farmer court and the court in the any additional decisions, a can wire appropriate court and catabit media account in his claims. The standard legal clause. Yeah, normally amount for any key claims at the court or model count.
Oh, okay. Into when plaintiff no, here every court no.
This is the bonnet of our plaintiffs, and them are court now. Court they have a deliberation or they will try this case to know who controls the funeral rights, whether the disease has already been properly buried, whether a second ceremony is lawful, and then the control of the disease legacy. Also, stopping them from a protest next like that court also ever find it out whether NIPA or control over those diseases. Any that will look a person in Ghana. And don't mean the family being maybe they are trials and out the him what I say. Really in some normal report, about the deliberation or all legal issues from this case, and the court will mainly decide who is the legitimate authority under the account law. So they are going to go to customary law and check all the provisions, then see NIPA legitimately, or authority. Now, Master I should say December funeral valid and not saying valid. No, Master I should last one say can another ceremony legally take place. This is a court, bobo. There are some brothers. Anything a justice is in the other. I'm not fair.
Number two, after say of filing case, of filing in the position of an Abusuapanin, right?
Yes.
Yes, because does that mean that if he is no more the Abusuapanin, this case nullifies?
So when you Abusuapanin, in terms of with the case make quarter.
Yes, because as I'm say, or the same way because social plaintiff as I'm the coin or say the plaintiff as Abusuapanin of the corner family. So they call in the power of Abusuapanin. What you are saying?
So he's seen in favor of all the family members. So
yes, but they call as Abusuapanin.
As Abusuapanin on the authority.
Yes. But the thing is that sir Abusuapanin or the Omoko court other members also of the family. So does that mean that if he is no more the Abusuapanin, the same way, engineer be man.
Onye Abusuapanin kwa obetumi case akoko under certain provisions. Yes, under first pan. Nanka Abusuapanin in a room to me obetumi akoko. The Abusuapanin wasn't accountable to any of the family members back then, but now Abusuapanin accountable to them. Some reasons I'm starting me like I said. And you must be an admin, it must be in the interest of the family members, the principal family members, and the other family members. And the other same way, Apple Court, that's where courts have been at the limit on these things.
But I'm going to be and say, Papa now the call court, it was a pain or the way call court. some few days ago, Abusuapanin to no. As Abusuapanin, you met to Nadia. So,
Nama of the case may for quarter. Na or that's Abusuapanin.
no, that's Abusuapanin. But see, Ometuni, on Abusuapanin.
It's so good. It's so good. And normally, when Abusuapanin after all the case for quarter, what they will do is that you're very fair, Nama put not to resolve the first. Going to me, and you take it there. And now, Obia won't find. We'll be saying Obia won't find say or the case in the court. If he a case we know a back quarter, he was then the Abusuapanin. What was there? But this year, then now can you tune at the so. And you say could do on or more deliberate on and you might be better sound provisions not the outcome because Siciano as a plaintiff there's no more they are paying again.
Okay.
You get it. So things will be changed there. The Opo was no media set. Recorded so on man. Or more recorded BPR during the course of the trial. Even the defendant can read that there is no more they are paying to. And the court will say an officer and say remote. I am more category or more an office of this record. Everything that you say there no, will be put on record. So it should be official and then it should be true. So the defendant can even read say it's so much it should be clarified there. They will make an amendment to that statement there.
So if Abusuapanin, can he as a single person set up a declaration, say obey the sole and exclusive authority to organize a funeral for someone when he is one person
but
and not
at the time
Abusuapanin?
that the first funeral right was being held, he was the Abusuapanin, right?
Yes. But now what he's saying is that on person will be able to
anything I make me can say court ebe should say obibe to me assign I biwana.
Okay.
So court will go into that and then talk about that. It's I tell me so they will really delve into it and even quite almost between there so they can even see say musicians it passed through the right channel.
Okay. Into when and your mother the coach now court name and a court also it's not some so 25th they train me and a court in the na court no so no and also my documents no send off the me reading I can also share more.
Okay.
Into conclusion no I think say point 13.
I know.
Conclusion.
No. The work plaintiff needing date ruling manager when defendants needing now.
Yes, in fact. Into I know about the next page. Into Osha the defendants no bomb yanko for.
Defendants are for Akosua Serwaa Robert James Yeki over Yakuku. And it's now Osu. And then Akosua Eki Papa She.
Yes. And the judge, a final here, a ruling, and a page 13, point 13,
Yes.
And to point conclusion, or say, thus, upon consideration of the processes so far filed, the court opines that the plaintiff, who sued as head of family and the defendants, there are obviously serious questions to be tried in respect to the customary law of the parties, which requires preserving the status quo pending a final determination of the suit. I am guided by the fact that the grant or refusal of an interlocutory injunction is discretionary and must be expressed judicially, fairly and candidly, taking the settled principles into account. In the circumstances, therefore, and in the exercise of my discretion, I hold the equities favor granting the instant application and same is accordingly granted. Pacha non ti asibi o manamento aso.
The man teaches Mukaka. Pusha we say, the court observed that the event is illegal or whatever on the customary laws and mandatory. So it could be rescheduled without causing irreparable harm. However, court acknowledges that there are serious questions regarding the customary laws that needs to be resolved in the full case. The move use judicial discretion. Then a court, granted the interlocutory injunction. That is the permanent ban. So, the interlocutory injunction, the defendant may be restrained from holding any event related to the letter of until the suit is finally determined. So, on the full trial. On the full trial. And then the plaintiff was ordered to give an undertaking to pay any damages the defendant may suffer if it turns out the injunction shouldn't have been granted. You see, other courts, almost the court of it. Courts are granted interlocutory injunction. Or time, I have two plaintiffs naming say, so we have full trial, maybe not so we say, and can you find say, almost interlocutory injunction to defendants as well. Plaintiffs said to give of any damages. Plaintiffs any option than to pay. Now the defendants now was again to file a statement of and then all the pleadings will be settled within 14 days. And of course we'll put only case now for 23 people. And so basically that document now send the man because you this is what about the social media.
Now, there's a part of it so I didn't really understand it. The paragraph 14, no, it said that I direct the defendant to file their statements of defense within the next 7 days, and all pleadings shall be settled in 14 days.
Never. Okay. Document.
Okay. So, are you ready? I mean to me. As I can you see be more.
Maybe a document for
paragraph 14. Hello.
Read it.
I'll say, I direct the defendants to file their statement of defense within the next 7 days, and all pleadings shall be settled in 14 days.
So, a timeline.
Okay.
A timeline. What's the timeline?
Okay.
So, defendants over 7 days to file their defense. Put the legal documents, all the pleadings within 14 days, so easy. That's not a honor, a chance. You say, what am I see here?
Every time, my trust.
Because of the timeline, course, so we have 7 days. So the other rules that the defendant should follow. So that's what taking a time to move the case forward and quickly. Because on that timeline on someone, you'll be happen of the what they say. So other defendant say, or 7 days okay obtain statement of defense. So I want to know Akosua you tell your side of the story. What they say. And you responded to plaintiff claims. Now so the also argument about go to the Senate. What they say. Senate let it not matter. It is a only to deal with man now to be will back.
Okay.
So all pleadings will be done in 14 days. No? It's just all formal documents from both sides. From both sides, if you have a formal document and within 14 days.
And sana 23rd, you are saying a court or being.
Yes. In our adjourning case, now 23rd April. It is that 14 days and the paperwork.
Okay.
Paperwork.
Okay.
When this me, I will pay the difference. We will respond it. Make it will respond it. Not plenty of new responding. Enjoy the timeline at the time. Or see, make defendants respond the statement of defense within 7 days. Enjoy the back. Both parties will be on legal documents. Official documents being now ready within 14 days. Because I said that I'm also talking about no shame. So I'm filing on the car. Judge no superstition. So by the time I'm over 23rd, no. Now that I am ready for the case. For the review, case no progress. Obama further instructions. Normally they call it directions. No affecting a trial date. I want to set a trial date on every amount. So basically the judge is saying let's not delay. Everyone
Okay. And I'm part after 23rd, you come back, you sign the back. Na komo bi o aye sign no with da se bebre se o dey na otimi ki sai
ma mincha which is one was just
e pa chi me chief on ma chef for se o da wase ne education o dey amomo e bi hwe na wi e bi hwe na no pe bi hwe na nyumere da se bebre nkupo nhira